Hi, welcome to the Blockchain Law Show. I'm your host, Onki Kwan, and in this video, I'm going to talk about the SEC's lawsuit against Kik. If you've seen any of my past videos, you know that the SEC staff notified Kik that they would recommend an enforcement action against Kik to the SEC. And they invited Kik to respond in what's called a well submission. And in their well submission, Kik laid out the arguments as to why the SEC shouldn't pursue an enforcement action against them. Needless to say, the SEC was not swayed by their arguments, so they filed a complaint against Kik alleging that they had violated the US securities laws because they were offering and selling securities without registering or finding an exemption from registration. If you have watched any of my past videos or you know about securities laws, you know that if you offer or sell a security in the United States, you have to either register your offering or you have to qualify for an exemption. This is because the US securities laws is based on a principle of disclosure. Under the securities laws, it's important to disclose information so that your investors can make an informed decision. When you register your securities, you have to disclose an extensive amount of information. That's because in a registered offering, you're selling your securities to the public, and this is to all sorts of investors, whether they're wealthy enough to be considered accredited investors or if they're not wealthy enough to qualify as accredited investors. And because you're targeting this broad range of investors, including people who can't risk losing substantial sums of money, the law is meant to give these investors enough information so that they can make an informed decision about whether to invest in your securities. That's why under the securities laws, you have to register your offering or qualify for an exemption. An exemption also requires you to disclose information, but the extent of the disclosure depends on whether you're selling to accredited investors who are these wealthy investors. And because they have this amount of money, the idea is that they can afford to lose their money as well. So if you're selling to accredited investors only, then you don't have to disclose as much information as you would if you're selling your securities to non-accredited investors. And it's also the case if you're advertising an offering, and this is, if you're advertising an offering, a lot of people can see that you're offering and selling securities. So if you're advertising particularly to non-accredited investors, your disclosure requirements become higher. So this is the reason why you have to register or qualify under an exemption to sell securities in the US. And if you don't do that, you're in violation of the securities laws. This doesn't require bad intent or any fraudulent intent. It only requires that you offer and sell a security without registering or qualifying for an exemption. So this is the basis of the lawsuit against Kik. The SEC is alleging that they violated the securities laws because they neither registered their offering nor did they qualify for an exemption. So let's talk about what happened in the Kik ICO. Kik decided that it needed to raise money because it was going to run out of money by, I think, October of 2017. So they came up with a plan to raise money so that they could extend their runway. They decided that they were going to cash in on the ICO hype, and they came up with a plan to raise money. They were going to sell SAFs to accredited investors, and they were going to sell tokens to the public at large. They raised half of their money through the SAF and the other half by advertising to the public and selling tokens to the public. It looked like they had intended to make a functional product using the money that they had raised from the SAF, but they didn't have enough time to create a product that was actually usable for tokens. But they weren't able to do that because of the terms of their SAF. Their SAF put in dire consequences if they didn't distribute the tokens by a certain date. If they missed the deadline that was set forth in their SAF, then they were required to refund 70% of the money that they raised through the SAF. Because of this, they were pressured to sell tokens before they had a viable product in place that actually used the tokens in the product. So they didn't create any product where there was an actual use case for the tokens when the tokens were distributed, is what I'm trying to explain. So there are two things that stood out to me in reading the SEC's complaint. The first is that this complaint is very, very similar to the allegations that the SEC made against other companies that raised money in ICOs, in that they were marketing their tokens to investors that wanted to invest in the tokens rather than people who were actually looking to use those tokens. In addition, Kik emphasized the efforts that they would use to make the tokens more valuable, and they didn't emphasize the use case of the tokens, and in any event, there actually was no use case. It also struck me that this is the first time the SEC has spoken out about SAFs, and in their complaint, we see their position on the SAF. It appears that their position is that a SAF is a security, and the asset that's being sold in the SAF, which are these tokens, are also securities. With that background in mind, let's get started. And that was a 10-minute intro, so maybe this should be the end of the video. In the US, as I explained, when you offer and sell securities, you have to either register with the SEC or qualify for an exemption. The SEC is arguing that Kik was offering and selling securities, and they violated the law because they didn't register, nor did they qualify for an exemption. That means that they have to prove that Kik was actually offering and selling securities. So the first question that arises is can a security, when a plaintiff files a lawsuit against a defendant, they have to allege facts showing that if the facts are true, it would prove that the plaintiff has a legitimate complaint against the defendant. So in the complaint, the plaintiff has to show facts proving their case. the SEC is setting forth facts to show that Kik offered and sold a security in the form of kin tokens. If you've watched any of my videos or if you've followed the SEC's proceedings against companies that did ICOs, you know that the SEC thinks that certain tokens are investment contracts. So they use the test for investment contracts called the Howey test to determine whether these tokens are securities or investment contracts. And I wrote down the elements of an investment contract so you can follow along. Under the Howey test, an investment contract, and therefore a security, contains 4 elements, and the 4 elements are: there is an investment of money in a common enterprise where the buyer expects profits from the efforts of others. And the efforts of others are generally the efforts of those people and companies that are promoting the ICO. So the SEC has to show facts that prove all of these 4 factors, because if they don't do that, then their case will get kicked out of court. As to the first element, this usually isn't something that a lot of attention is paid to, because there's always an investment of money in an ICO. The reason for this is because you're exchanging crypto or USD in some cases for tokens. So there's an investment of money. Common enterprise looks at whether the profits and losses of the company are linked with the profits and losses of the investor. And in the case of Kik, the SEC says that the profits and losses of the company are linked to the profits and losses of the investor, because Kik, they have 90% of the tokens, and they're using their efforts to make these tokens more valuable. So if the tokens increase in value, then the investors, their tokens will increase in value, as will Kik's tokens, because they're the same tokens. In addition to that, Kik is also using the money that they raised from investors to make those tokens more valuable. And because of this, the profits and losses of Kik is linked to the profits and losses of the investor. So they allege those facts to show that a common enterprise exists. But in these cases, the SEC usually focuses on whether the buyer expects profits from the efforts of others. The SEC alleges numerous facts showing that the buyers of the kin tokens are expecting profits from the efforts of Kik. A few of these reasons include the fact that Kik has to use its efforts to build the ecosystem. In other cases where the SEC alleged that companies had violated the securities laws, in those cases, these companies also raised money, sold tokens, and there were no use cases for the tokens whatsoever. The SEC states that when Kik sold their tokens, there was no way a buyer could have used the tokens for anything. They couldn't purchase any goods or services on Kik's website, and there was no use for the tokens except to exchange it for other types of crypto on exchanges. They did create an MVP where if you bought kin tokens, you would get stickers, but this wasn't actually advertised to investors. So if you didn't buy any KIN tokens, you wouldn't have known that you were able to get these stickers because it wasn't advertised. Kik focused their advertising on the value their investors would receive in buying these tokens. Because of this, the SEC argued that any profits that a buyer would expect is based on the efforts of Kik. The SEC alleged these facts to show that the KIN tokens are securities under the Howey test. And like I said before, if you're offering or selling a security, you have to either register with the SEC or qualify for an exemption. And because Kik didn't do either, they're in violation according to the SEC's complaint. And because of this, the SEC asked the court for 3 types of relief. One is that they want Kik to stop offering and selling securities in violation of the securities laws. They want Kik to disgorge any profits that they made from the offer and sale of KIN tokens. And of course, they also want KIN to pay interest on top of those disgorged profits. And finally, they want Kik to pay a fine because they are violating the securities laws. In other cases where the SEC settled with companies that did ICOs, they gave them an opportunity to come into compliance with the law. So for example, in the Paragon and AirFox cases, the SEC said that if you come clean to the SEC, then you can come into compliance with the law. And that includes registering your tokens as securities, offering your investors a refund, and they also fined Paragon and AirFox. I don't remember the fine exactly, but it was probably lower than they would have fined a company otherwise. But because in this case, the SEC is suing Kik, they may not offer Kik the opportunity to register their securities their tokens as securities to come into compliance. But we'll see. Kik may offer to settle with the SEC, and the SEC may offer the ability to register their securities as part of the settlement like they did with these other companies. But this is something that we'll have to wait and see to see how this will play out. I hope you found this video helpful. If you did, please share. Thank you so much for tuning in, and I hope you have a fantastic day. Goodbye.